Yes. So yeah. Hmm. It's an admission only. Will pass the necessary order. Don't. Don't. Okay. Or open item number one. Mr. Amit, take it. Mm. Yes, Mr. Ahmed, just tell us one thing. Whether in a suit or any other case, that if you do not state in your plain or in your objection,
As per record, my lord. I
can
have
you
not.
add any new thing in your written evidence in affidavit? Written evidence in affidavit is to only to supplement the facts that you have stated in the your written statement or your reading. Now, can you add any new thing? First of all, tell us. And tell us which particular law allows that. Which particular law allows that? There's a reason behind that, because both of us has looked into the records of your case and everything. The petitioner is very intelligent. Did not enact the written statement. That's why we had to go through the written statement.
My lord, written statement not provide me, my lord.
I'm not saying the
Yes.
petitioner, the words are very specific. Petitioner is intelligent.
Yes.
That
And
is
that
why
part I
she
cannot
did not provide you.
whether she is intelligent or not. I
Now,
don't know.
help us by reading this.
Yes.
This is her written statement. Kindly read.
Yet the opposite party denies the allegation that she is not an Indian citizen and an immigrant migrant of the some other country. That the opposite party's grandfather name has been enlisted in 1965 of 1696 Shorupatar constituency, district Shivsagar under Morangi Moja, white serial number so under so as a certificate is annexed carried and marked as annexure 1.
Now here she stated, did not state the name of her grandfather, grandmother, father, mother, brother, sister, nothing. Saying that her grandfather's name figured in the voter list of
1965.
1965, house number, this serial number he
Yeah.
has mentioned,
Yeah.
and from Morongi, Morongi village,
Yes.
Morongi,
Moja.
Moja. That much she say. Now come to para 2.
Yeah.
Page 75.
A death and affidavit showing that I'm the Shofikur Rahman, son of Jamirat Ali, is the father of the Opui, is annexed carried and marked as annexure 2.
So by a self-shown affidavit, he
Yes.
has said
Yes.
that
That a school
Safikur Rahman
certificate.
is the father, son of
Yes.
Jamirat Ali.
Yes.
Then 3.
This
Para 3.
written statement, my lord, is casual, my lord.
No, that is
Only
why we want to know.
2 pages say
No, no, then
that a school certificate issued by Sancho Soikia Am Vidyalaya of Pio Morongi, Chariali district, Golaghat, showing the date of birth of office 1/9/1985 is annexed herewith and marked as annexure 3. School certificate, my lord, where her date of birth is mentioned, my lord, 1985. There the opposite party is the bona fide citizen of India and has has full allegations to the constituency as intent, and that the opposite party neither a doubtful citizen nor has connected anything, and the voter list of her grandfather and other recent documents are the constitution proper as a proof of her Indian citizenship. That the opposite party shall adduce the evidence and will submit additional documents at the time of hearing. There is only, my lord, two things.
There is nothing here.
Yes, nothing here in this.
How many brothers, sisters she has?
Nothing, my lord.
There is nothing.
Even, my lord, her date, where she is born, my lord, that is not mentioned.
So now,
Nothing mentioned.
filing a written evidence.
But in the written evidence, my lord, I have seen, my lord, in my writ petition, my lord, yes, everything is stated.
Is it acceptable?
Yes.
That is why we are asking you. If it is a case not pleaded, if it is not in the pleading, and bringing all these things in written evidence in affidavit, is it acceptable?
That part, my lord, was, my lord, very unfortunate, my lord. That is the written statement, my lord, only 3 or 4 paragraphs.
This is one.
Petitioner is a illiterate person, my lord. He does not know
Question
how the
of-
written statement written, my lord.
Thing
This is the duty of
illiterate person
Hmm.
is not the thing. As you have seen, particularly to any decision to be taken under the Foreigners Act, the Constitution bench of the Honorable Apex Court has clarified that it is only with the knowledge of the proceeding and nobody else.
Hmm.
And that is why it is the duty of the proceeding to lay down everything. Now, we do not blame anyone, neither the concerned counsel who is representing the proceeding, because unless the proceeding says before the lawyer, how the concerned lawyer will able to state something before the tribunal?
proceeding stated. In
So,
my view, my lord,
proceeding is
proceeding
so
stated
silent
everything, my lord.
regarding-
That's why, my lord,
see,
in the
regarding her
written
everything.
evidence, my lord, in the written evidence, my lord, she has stated everything, my lord.
Is it
Details, my
possible
lord.
to accept? That is the reason we are asking you.
Yeah.
Had so many brothers, sisters, grandfathers, grandmother's name, step grandmother's name, the mother's name, how many siblings they have, everything.
Yeah.
Can it be added? And that also without the leave of the court.
All documents submitted, but nowhere mentioned in the written statement, my lord, written statement about the documents, my lord, which is
That
annexed
is why I am
with the
asking you,
evidence.
is there any law that if you do not plead before the court, you can bring all those things by filing your written evidence in affidavit? Is it possible? So if so, in which particular provisions of the CPC or any other laws or by decisions of any court of law? The other documents she have exhibited before the tribunal were not proved. Now, 2 particular teachers, one for her projected father, another with regard to her school certificate. Both the headmasters adduced their evidence.
Yes.
Now, coming to the headmaster of the school in which the proceedings studied, he clearly stated that there are some corrections without any signature.
Yes, yes. That part I have
Gave the
seen in the
photocopy of the register. Now, see, there is a system. Whenever somebody is admitted, the guardian's name and the parent's name, there has to be a signature. Leaving aside that, the headmaster have categorically stated who have deleted the name, the first name of the petitioner,
Yeah.
then again incorporate the second name, it's not known. He was not the headmaster. Then the counterfoil different. The counterfoil was 75, whereas the place before the tribunal was 76. He said from where it has done, and he has not brought any record to show that before the tribunal. That's the evidence of the concerned headmaster who issued the school certificate to the petitioner. Now, with regard to the father, projected father who adduced evidence as DW2, the concerned headmaster who issued him the certificate to show him that he is Sofikur Rahman, son of Damirat Ali, he clearly deposed that he didn't bought anything, he did not place any record before the tribunal. And whatever has been stated by Sofikur Rahman, he has written and gave the certificate. This is his own admission. These are the independent two witnesses. Now, coming back to the projected father, has been recorded by the tribunal. There you have seen, here the tribunal has specifically mentioned that yes, there has to be some Zamirat Ali sometimes in 1966, 1970. There is no issue. But after 1970, their existence is not there. Thereafter, the projected father's name figured in the voter list, but the name of his father is not there. Whose father? That Zamirat, that Safikur Rahman's father is not. Thereafter, the 85 voter list.
In 1977 voter list mein lot Shafiqur Rahman Zamirat mein.
In 1985 voter list, it is not there.
Yes, in 1985 mein lot her father's name se against
Now,
father name not
difficulty is,
there.
you see, voter list is together, it is there, but house numbers are different. Not from the same house.
Voter list 1985 mein lot same house mein 2929.
See the 1977.
77 mein lot house number 407, serial number 407, 408, house number 120, 120, 121, 121.
So that's simply, there are two different houses. As you know, these are the issues. You cannot say the same person.
Fazlur Rahman is the paternal uncle, man, whose name appear along with the grandfather Zamirat Malot in voter list of 1970.
That is, yes, it has to be in the same house, right?
Yes.
From a different house.
Subsequently, a different house is Malot created. As per voter list.
So they are not in the same house.
Village are same, man.
Village,
Village, Moja,
so
everything
many
is
people
same.
lives in one village.
A campus is same, my lord.
How will you
407, 408, 409, 40.
How will you know? It's a different house number altogether.
408, 408. More for
Up to 1970, there is no issue.
After from 85, my lord, in voter list of 1985, my lord, why grandfather name is not appeared, my lord? That part, my lord, I think, my lord, election commission standing council, he may
Not required at all. It is the case of the prosody. That is where we are saying every time.
And this is the certified copy, my lord. She applied for
Definitely,
certified copy, my
copy,
lord.
we believe on that.
They provided, my lord. It is not created by the
We
petitioner.
believe on that. That is the reason we are saying that the house numbers are
Father
different.
name is appear, mother name is appear, my lord. Against the father name, not mentioned, my lord. Dot. This is the system.
You have enclosed the voter list of 1970 of Jamirat Ali,
Yes.
and according to the petitioner's father, the position, Jamirat Ali expired
In
when,
1970, my lord, as per written evidence, my lord, cross part, my lord.
in as per the deposition of petitioner's father, Jamirat Ali expired while he was 20 years. Right?
Yes.
Now in 1977 voter list, petitioner's father is 21 years.
Yes.
And that is why Jamirat Ali is not there in the voter list of 1977.
Yes.
Good.
70.
No, in 70, Jamirat Ali is there.
Yes, yes.
So in 1997, sorry, 1977, Jamirat Ali is not there because
Expired in 1970.
petitioner's father expired in, father, petitioner's grandfather
Grandfather.
expired
Yeah.
while his father was 20 years. And in 1977, her father was 21.
Yeah.
So necessarily his name is not there.
Yeah.
Mr. Ahmed, kindly tell us how many elections were held after 1970?
Nine.
Assembly, parliament.
Yeah.
How many?
In 1977.
We have the records before us. That is why we are asking. That is why I am saying petitioners are very intelligent.
I don't know. That is incredible or not, my lord.
See, only when which particular voter list will carry it in name or whatever to prove, the petitioner will get this, give only those kind of certificates, not the others. In between 1970 and 1977, there are two elections. For your information.
In between 1970 and 77.
One assembly, one party.
One.
So that is how the petitioner is.
Petitioner.
Now, please come to the evidence of DW3. Come straight to the vernacular at page 44.
Yes.
Will you able to read?
42. Mm,
Okay, I will read it for you.
42.
মোৰ নাম শ্ৰী অশোক বৰদলৈ, মোৰ বয়স 51 বছৰ। মোৰ দেউতাৰ নাম মৃত তুলসীনাথ বৰদলৈ। ঠিকনা গাঁও পানীপৰা গাঁও,
Yes.
পোষ্ট অফিচ মৰদী চাৰিআলি, থানা আৰু জিলা গোলাঘাট।
গোলাঘাট
2013 চনৰ পৰা
পৰা
মই উক্ত স্কুলত ইনচাৰ্জ হেডমাষ্টাৰ হিচাপে কাৰ্যনিৰ্বাহ কৰি আছো
আৰু
আৰু 2017 চনৰ
পৰাই
আগষ্ট মাহৰ
Yeah.
should have been পৰা it is dropped,
নিয়মীয়াভাৱে
নিয়মীয়াভাৱে উক্ত বিদ্যালয়ৰ হেডমাষ্টাৰ হৈ আছে।
আছে।
প্ৰদৰ্শক পাছ বিদ্যালয়ৰ
বিদ্যালয়ৰ
প্ৰমাণপত্ৰ আৰু প্ৰদৰ্শক পাছ ক মোৰ
চহী
চহী আৰু চিল।
ঠিক।
উক্ত প্ৰমাণপত্ৰ মই ছফিকুৰ ৰহমান, পিতা মৃত জমিৰত আলী, within bracket he has written, ছফিকুৰ ৰহমানে কোৱা মতে তেওঁ বিদ্যালয়ত পঢ়ি থকা কালত জীয়াই আছে।
আছে।
ঠিকনা গাঁও ঢুলীয়া গাঁও, থানা আৰু জিলা একো উল্লেখ নাই। উক্ত ছাত্ৰ ছফিকুৰ ৰহমান 31/12/1967 ক্লাছ 8ত পঢ়ি থকা সময়তে আগৰ
আমাৰ
বিদ্যালয়খন এৰি যায়।
যায়।
তেওঁৰ জন্মৰ তাৰিখ 5/12/1948 হয়।
হয়।
উক্ত প্ৰদৰ্শিক পাছৰ কাউণ্টাৰ ফইল
ফলিঅ'ৰ
মতে চিৰিয়েল নাম্বাৰ হ'ল 75, কিন্তু
উম।
প্ৰদৰ্শক পাছৰ মতে চিৰিয়েল নাম্বাৰ হ'ল 76।
উম।
প্ৰদৰ্শৰ পাছৰ লগত সম্পৰ্ক থকা
মূল
কোনো
নথি
মূল নথি মই আজি আদালতত দাখিল কৰিব পৰা নাই। প্ৰদৰ্শক পাছখন মই ছফিকুৰ ৰহমানে কোৱা ধৰণে মই তথ্যবিলাক লিখিছো। এইটো সত্য নহয় যে উক্ত প্ৰমাণপত্ৰখন মই
ছফিকুৰ
ৰহমানক দিছো।
উক্ত
উক্ত প্ৰদৰ্শক প্ৰমাণপত্ৰ দিয়াৰ আগতে কোনো সোধ-পোছ কৰা নাই। So clear has been told by Shafiqur Rahman, he had given this certificate. Now, if the date of birth is 5th of December 1948, as per the school record, to be accepted that the Shafiqur Rahman is a son of Jamirat Ali, then when he was eligible to vote, he was eligible to vote in the year 1969. So his name should have been figured in the voter list of 1970, 1971, 1972, 1977, all the way.
48 plus 21 minus 69.
69.
His name may be recorded in the voter list of 1970.
He did not annex. And father's Jamirat Ali's voter list is there at 1970.
Yeah.
Then the deposition of the Shafiqur Rahman.
Page 38.
The Prosity Anjuma Begum is my own daughter. The Prosity was born in the year 1985 at village Duliagaon, but I have forgotten the date and month of her birth. I had 2 sons and 5 daughters, namely Jasmina Begum, Rusana Begum, Manjufa Begum, Anjuma Begum. Again, she has written Anjuma Begum. Ahmed Hussain, Taibul Rahman. The age of Jasmina is 48 years. The age of Anjuma is 36 years. I have forgotten the age of other children. The proceeding was given marriage to Sahubuddin, son of Piaruddin of village Merapani, Islampur, in the year 2001. I could not remember the date of her marriage. She has been still residing at village Islampur. She has 2 sons, namely Harishuddin and Arifuddin. The proceeding did not cast her vote before her marriage. The name of my father is Damirot Ali, and mother name is Kulsum Nessa, and name of my stepmother is Hajira Begum. My mother had 3 sons and 3 daughters, namely Faizur Rahman, Sabina Khatun, Saira Khatun, Shafiqur Rahman, Fazul Ali, Razia Begum. I have forgotten how many sons and daughters my stepmother had. My mother died at the age of my 10-12 years, and my father died at the age of my 20 years. My stepmother died before 3 years. I cast my first vote from village Duliagaon, India, 1977. My father cast his first vote from Duliagaon, but I have forgotten in which year he cast his vote.
I have forgotten
I
when
have
my mother
forgotten
cast
when
her
my
vote.
mother cast her first vote. I
I
was
was born and
born
brought up at
at
village
village
Duliagaon.
Duliagaon, but I do not know since when, since which
Which
years
are my
my ancestors
ancestor.
have been living at village Duliagaon. The name of my wife is Elina Begum. I solemnized my marriage in the year 1971. It is not a fact that the proceedee is not my daughter. The name of my father and my grandfather, Zamirod Ali, Ulas Mineswar Ali. I have forgotten the name of father of
Minister.
Mineswar. This is not a fact that I am not the son of Zamirod Ali of village
Okay.
Duliagaon.
He has explained many all things. Father, mother, everything, date of birth, date of year, date of year of village, everything.
Anything to add? This is your case, right?
Yes.
Yes, Mr. Pang. If you want to see the records, record is with, can look into it. Just uncover the microphone. The file has the
Yes.
Your Lordship may kindly see, as your Lordship has pointed out, whether the petitioner can go beyond the pleadings stated in the WS or the written representation. Hello, that
She want to link herself with Shafiqur Rahman,
Yes.
son of Jamilata.
Yes, madam. That, my lord, your Lordship may kindly, I would just like to read out the Rule 3 of 1964 order procedure. Only one para, my lord. It will clear. Because this is although it is settled, my lord, it is settled provision of law that the pleading the
Rule 3.
1964 rule order
Please.
tribunal. The tribunal shall serve on the person to whom the question relates to a copy of the main grounds on which he is alleged to be foreigner, and give him a reasonable opportunity, when this word may be seen, give him a reasonable opportunity of making a representation and produce evidence in support of his case. And after considering such evidence as may be produced, and after hearing such person as may be desired to heard, the tribunal will submit its opinion to the officer or authority specified in this behalf. This point has to be seen. It is clearly seen that reasonable opportunity of making a representation. The representation must contain the details, whatever he wants to submit. There is no other provision in the rule, in the order, of giving any kind of evidence or any representation or any manner of application. So, this representation, if we accept in the form of WS, my lord, it must contain each and everything, whatever the petitioner or proceeding wants to plead. Beyond it, he cannot plead, my lord. He cannot reverse beyond the pleadings, my lord. That is settled provision of law. This is clear. Reasonable opportunity of making representation and produce evidence in support of this. And this has to be done within 10 days, my lord. So he cannot reverse beyond the representation or in the form of which is filed in the form of written statement, and they produce evidence to that effect. That is settled. But I just wanted to point out this provision of law because there is no other provision, my lord, whereby the petitioner can bring any representation or any other document or any, my lord, anything to the tribunal.
Yes.
So he cannot go beyond the representation And that is settled, madam. Numbers of judgments are there. In fact, I would like to point out one judgment of this honorable court where it is said numbers of judgments are there. Your lordship may kindly note it down, my lord. This is 2017 4 GLR 670. They are in para 12.
2017
17 4 GLR
4 GLR.
5 GLR, my 5 GLR 670.
Hmm.
Zahirul Islam, my lord. In this case, para 12, my lord. Seventeen 5 GLR 670. Para 12. Zahirul Islam.
It's wrong. It's 5 GLR
Yes, ma'am. 17 5 GLR
670.
670. Your lordship may kindly see WPC 7347 of 2016. 36 WPC number.
Zahirul Islam.
Yes, ma'am. Para 12. Para 12 it is statement. In a proceeding before the foreigners tribunal, written statement is the basic statement of defense of proceeding. When citizenship of a person is questioned, that too by the state, it becomes the bounden duty of the
There are
proceed.
12.
Para 12, my lord. May I read, my lord? In a proceeding before the foreigners tribunal,
It starts with in a proceeding.
in a proceeding, madam.
The paragraph 12 begins with that sentence.
Yes, madam. In a proceeding. Page 674, madam. In this GLR. In a proceeding, may read it, madam. May read it. There is another internal para 12, my lord. That's why probably it is.
What is the WPC number?
Zahirul Islam, WPC, my lord. 7346 2016.
46 or 47?
7347, madam. 7347 2016.
Is that not?
16570.
Because the paragraphs are not matching. The previous paragraph just read 11.
11, madam.
It starts with
My lord, there is internal paragraph. Now, that's why your lordship may kindly say. After para 9, my lord, there is one quotation that begin with para 8. That there it is a para 12. Probably.
got
your
it.
lordship is-
Yes, you're right. Read
Yes.
paragraph 12.
Yes. Then next minute, it is again starting from para 10, 11, and 12. Okay.
Yes.
Page, yes. In a proceeding before the foreigners tribunal, written statement is the basic statement of defense of a proceeding. When citizenship of a person is questioned, that too by the state, it becomes the bounden duty of the proceeding to disclose all the material facts for providing the citizenship, which is especially within his or her knowledge at the first instance itself. That is in the written statement. This is the requirement of Section 106 of the Evidence Act, within Section 9 of the Foreigners Act 1946, which has been explained by the Supreme Court in Sarbananda Sonowal, showing so failure to disclose such material facts at the first instance, that is, in the written statement, may result in drawing adverse inference against the proceeding. So this is settled. There are a number other judgments of also. I like to point out those judgments on the same line. 2017 4 GLT 346 Rasminara Begum. There also same proposition is laid down. Then 2017 3 GLT 490 Aisha Khatun.
390.
490.
Take your seat, Mr.
Then 2017 2 GLT 1076 Momin Ali
2017
2 GLT 1076.
10.
Yes, my lord. 1076. All these are in the same footing.
Oh.
So it is settled position that he cannot go beyond the pleadings, whatever pleaded in the WS. He has to prove that much only by bringing reliable, cogent, and admissible evidence. Now, second part, the petitioner has to prove that either she is born in India prior to 1971, or she is daughter or granddaughter or son of the person who was there existed in India prior to 1971. The petitioner, my lord, apart from all other facts, as your lordship have already pointed out, the father's existence prior to 71 is not there. Though one school certificate was brought, that was much later, issued much later, and the
See, it is the fact that the procedure himself said in India 1977 he has given pass.
Yes.
So in the 1977 his existence is there.
1977, my lord.
But
Father's
prior
existence
to
is
that,
prior to that there is no.
and to show that he is the son of Samirat Ali,
Yes.
he produced the evidence of
Of headmaster.
the school certificate as well as the contract paper.
Yes, that discrepancy is there, my lord.
That has been placed. So his existence before 1977 as
Yes.
per the record
Is
is not.
not there. Now, my lord, even though we accept the headmaster was correct, then the proceeding could not produce the father's existence prior to 71, because headmaster said that as per the school certificate, he was born in 1948. So at least some documents prior to 71 should have been there. Here, the main question is whether any documents prior to 71. There is no single document of prior to 71. Now, second issue, my lord, even though the father was there in 1977 or 77, whether the petitioner could prove that she is the daughter of that person or not.
That
That-
also not been proved.
That is also not proved.
Both ways.
Both ways. The father could not prove that he was there prior to 1971, and daughter could not prove that she is the daughter of that person, or granddaughter of my lord, that Jamilat Ali, who was there in 1971. Now the petitioner, my lord, so only his evidence, her evidence was that my lord, is one school headmaster who came before the honorable court tribunal and adduced his evidence in support of the school certificate. But there also, as your lordship, if your lordship go to the evidence of DW4, that is, my lord, the evidence that may be seen, my lord, the headmaster, the DW4, at page 46, my lord.
Asiruddin, yeah.
This is important. My lord, may I read the মোৰ নাম Asiruddin Ahmed, মোৰ বয়স 52 বছৰ, মোৰ দেউতাৰ মৃত নাম মৃত বাছিৰুদ্দিন আহমেদ, ঠিকনা ফলগুল, বালিজান গাঁও, জিলা থানা গোলাঘাট, অসম। মই 2016 চনৰ এপ্ৰিল মাহৰ পৰা উক্ত বিদ্যালয়ত হেডমাষ্টাৰ ইনচাৰ্জ হিচাপে কাৰ্যনিৰ্বাহ কৰি আছো। হি হেজ বিন দেয়াৰ ফ্ৰম 2016 on.
As insert it now.
Yes, as assistant. প্ৰদৰ্শক 1 আমাৰ বিদ্যালয়ৰ পৰা দিয়া প্ৰমাণ পত্ৰ। The certificate was issued from their school mother. আৰু প্ৰদৰ্শক 1 মোৰ আমাৰ প্ৰধান
আগৰ, the previous
মোৰ
headmaster.
আগৰ প্ৰধান শিক্ষকৰ চহী আৰু ছিল। উক্ত প্ৰমাণ পত্ৰ মতে চকিবুৰ ৰহমান ছোৱালী অঞ্জুমা বেগম, ৰহমানৰ ছোৱালী অঞ্জুমা বেগম, ঠিকনা ধুলীয়া গাঁও, আমাৰ বিদ্যালয়ত পঢ়িছিল আৰু 31/12/2001 তাৰিখে ক্লাছ 9ত পঢ়ি থকা কালতে তেওঁ আমাৰ বিদ্যালয় এৰি যায়। আমাৰ বিদ্যালয় এডমিশ্যন ৰেজিষ্টাৰ মতে 1/9/1985. This is probably he was saying the date of birth.
Part of the property.
Birth of the property. উক্ত প্ৰমাণ পত্ৰখন মই দিয়া নাই। He has not issued the certificate. That has to be seen, madam. উক্ত প্ৰমাণ পত্ৰখন 10 বছৰ পিছত কি তথ্যৰ ওপৰত ভিত্তি কৰি দিয়া হৈছে সেইটো মই ক'ব নোৱাৰো। This part is to be seen, madam. উক্ত প্ৰমাণ পত্ৰখন 10 বছৰ পিছত কি তথ্যৰ ওপৰত ভিত্তি কৰি দিয়া হৈছে মই নাজানো, ক'ব নোৱাৰো। কিন্তু সিৰিয়েল নম্বৰ 37 আৰু সিৰিয়েল নম্বৰ 39ত একে নামৰ দুগৰাকী ছাত্ৰীৰ নাম উল্লেখ আছিল। কিন্তু 37ত থকা নামটো সম্পূৰ্ণৰূপে কাটি দি সেই নামটো পুনৰ সিৰিয়েল নম্বৰ 39ত উল্লেখ কৰিছে। 37ৰ নামটো কোনে কৰ্তন কৰিছে সেইটো মই নাজানো। উক্ত নাম কৰ্তন কৰা ঠাইত উক্ত চহী মই মূল নামত থকা
উক্ত চহী নাই।
উক্ত চহী নাই। মূল নামত থকা অঞ্জুমা বেগম, মূল নথিত থকা অঞ্জুমা বেগমৰ নামত থকা ৰেজিষ্টাৰ বহী এটা ফটোকপি মোৰ স্বাক্ষৰ লগত দাখিল কৰিছো। So, photocopy of that photocopy is submitted. He has not brought
The
original, first of all. Secondly, he admitted, my lord, from the, even though the photocopy is there, my lord, in record, if we see, my lord, he admitted that there are 2 names and one is struck out in the same register, in serial number 37 and 39. And who has struck down? We don't know. So, on the basis of this evidence, further, my lord, the certificate, if we see the certificate, my lord, certificate is probably next. Page 28. Certificate of the petition. If we see the certificate, my lord, certificate says some Dondeshwar Saikia UM Balika Vidyalay. Yes.
উচ্চতৰ মাধ্যমিক।
Yes, ma'am. উচ্চতৰ মাধ্যমিক বিদ্যালয়। So, the transfer living certificate certified that Anjuma Begum, daughter of Safiur Rahman, inhabitant of Dhulia Gaon, left his school on 31/12/2001. That may be, my lord, reveals from the register, but he was in class 9. Her date of birth, according to admission register, is 01/09/1985. But this register doesn't provide anything. My lord, that what was her date of birth? The register, my lord.
First of all, those photocopies doesn't show that it belongs to that school.
Yes.
Name of
No,
the school
no,
is not
no,
there.
no name of the school, no year, no seal.
You'll get in one copy, that is 1999.
This is admission register of the photocopy. The school name is in the register book obviously, but year is not clear, my lord.
In the second page, that register doesn't contain any down seal, nothing that it belongs to that school.
That is all these are my lord photocopy. In fact, these are photocopy. These have no evidentiary value. However, my lord, the no seal and no signatures of anyone. This is member for instance, member for instance.
Somewhere you'll get 1999 at the top.
99 is there.
99 is there some.
Yes, 99 is there. 1999. So, well, at admission register, this cannot be because he was reading in class 9 in 2000, 2001. So it should be registered.
No, she left the school in class 9 in 2001.
Yes. In-
December
There is-
31st, she left that school.
Yes, ma'am. So 99 registered her name. And in the first first serial number 37, which is struck out. In fact, the handwritings are also different.
But
From
not on that.
serial number
Basically, the evidence itself says
Yes, evidence
Two
itself
things.
says where they have
two
not.
documents, right?
Yes, then the second name, people, 94.
No, that's clear line, no?
And
মোৰ
there are-
নথিত থকা অঞ্জুমা বেগমৰ নামত থকা ৰেজিষ্টাৰ বহী এটা
Yes,
ফটোকপি মোৰ
Photocopy.
সাক্ষৰ লগত
Yes.
দাখিল কৰিব।
Yes.
It's a clear view that's
there
photocopy.
there is no original was not produced. And surprisingly, my lord, if it is the register of 1999, if it is of 1999, my learned friend has shown from the photocopy, my lord, the name was struck, against the name is struck, where the name is struck out, as per him, my lord, there is an initial. And that initial is of 30/12/1994. 94. So,
Photocopy, not the original.
not the original.
Whatever is there, it is there.
Yes,
You know,
well,
can already discuss on that.
so this
Anything
is-
else?
this is- so that must be, my lord. So my lord, the link of the petitioner to link the petitioner to link herself produced a school certificate that was not proved properly, and the headmaster who came, my lord, without any original record, he has not said that, but on the basis of any contemporaneous record. So whatever he stated, it is personal in his personal knowledge, and she could not see, and she has clearly said she has not produced any document, only the school register, photocopy of one school register is submitted. So that must mean that if in absence of this evidence, there is no link document of the petitioner to link herself to his projected father or to the grandfather. That must mean.
Give it to us. Not Mr. M. Council for the petition. Mr. S.S. Roy. CGC for the restaurant number 1. Also heard Mr. J. Pang, Standing Council Home Department, Assam for the restaurant number 2. 4. Mr. P. Sharma, Additional Senior Government Assam for the restaurant number 3. Mr. A.I. Ali, Standing Council, Election Commissioner for the restaurant. There is the records of FTG within bracket T, case number FTG within bracket T 388/2010 that was called for by order 1503/2024, where the impugn opinion dated 28/12/2023 was passed by the Lord Furnace Tribunal. Your heart. Opening the petition for it. 25 of 4/25. Next. Yes, Mr. Chaudhary. You have gone to the record. Tell us. There is the illegality in the order passed by the tribunal. Sharma. Yes. Yeah.
I have gone through the entire record, WS and evidence. From the available documents from voter list, no linkage can be established as there is no continuity of voter list. Opposite party's father expired in about 4 or 5 years back, but voter list is furnished only in 1965 and 1971, wherein only can be detected that one Fazar, son of Azim, cast vote in 1965. Similarly, from 1971, voter list it can be found that one Abdul Khalik is the son of Fazar. The land documents that is so and so are not proved. So I'm not on that minor. Next page, minor. It is a settled law that they're making so and so. Next paragraph. In the above facts and subtle portion of law, I find that there is no credentiality of the evidence of the opposite party in support of her case. She has failed to establish the linkage of the same so and so. So the stress was given on the linkage minor. Now come back to page 19. Third para, the DW3 madam. This is a statement of the Gaonbura madam. DW3 Sri Nirmal Chandra Roy has stated in his evidence that he is the village headman of village livelihood since 13 years back. He knows opposite party Ajida Khatun, daughter of Abdul Khalik, residents of village livelihood. Opposite party's grandfather's name is late Fazar Ali, and his name appeared in the voter list of 1965. Opposite father's name appeared in the voter list of 1971, and he had cast vote till his death. Exhibit 7 is the certificate issued by the DW3, and Exhibit 7(1) is his signature. In his cross-examination, DW3 has stated that he has been serving as village headman since 13 years back, and he was born in 1976. After marriage, opposite party Ajida is being permanent resident of the village of her husband, but he does not know when Ajida was married. This is the statement of DW3 minor, but the same has not been taken consideration by the London Tribunal. I don't know why, my lord. In fact, the mother of the petitioner is still alive, my lord. She has deposed as DW2, my lord. The same thing has not been taken care of. I don't know why, my lord. So there is blatant illegality on the part of the tribunal, my lord. At least this has to be taken care of, my lord. Why? So these are vital evidences, my lord. The sole purpose of the Gawra statement is to establish the linkage.
Can Gambura issue certificate? Where is the authority?
Generally, Gaon,
Where is the authority?
actually, my
Which
lord,
provision shows that he has the right to issue certificate? Gambura comes under which provision? It is available in the Assam Land Revenue Regulation. Where is those provisions in the Assam Land Revenue Regulation? That he has the power to issue such certificate in the Assam Land Revenue Regulation.
generally, my lord, Gaon Panchayat issues the
That has been accepted by Honorable Supreme Court.
my lord.
Right?
Mal.
Is there anything in that judgment that even the certificate issued by the Gambura will also be accepted?
No, not here.
Now, you have gone through the record whether that Gambura deposed before the tribunal anything from record or from his personal knowledge.
That is not clear, man.
Did he produce any record before the tribunal? While to subcase that the certificate that he had issued in favor of the proceeding
Right.
was on the basis of any record that he is to maintain as a Gambura.
Yes, my lord.
Is it there in the evidence? Is it there in the record? Did he say it so?
It just simply states that I know her.
That is his personal knowledge.
Mm, mm.
Will that do?
No, my lord, but whether that is
That is
another
the
thing.
reason. See, things are like this. First of all, a Gambura should be competent enough to issue such certificate. Now, first is first. The second is whether he deposed before the tribunal that he had issued that certificate on the basis of records that is maintained by the office of the Gambura. Personal knowledge, in that case, so many parents will come before the tribunal. So many uncles, so many aunts, brothers, sisters, mama, mommy, everyone will come. And we're able to say that she's my nephew, she's my daughter, she's my sister, she's my aunt.
That is there, my lord.
So
But the tribunal, what tribunal has
is it
done,
not?
my lord?
Is it required? That's the thing. Where is the jurisdiction? Where is the power? Where is the competent authority? Is the Gambura is competent authority under the Assam Land Revenue Regulation? Has been empowered to issue such certificate.
A government certificate is generally issued, my lord, by the government.
Issued, but where is the authority? Where is the power? That is the reason we are asking you.
And the government certificates are taken seriously by the tribunal also.
That is where is the power? First of all, see, we have accepted that the Honorable Apex Court in the case of Rupajan Begum has clearly said that the certificate to be issued by the Gaon Panchayat secretary. Because many cases, what happens, the lady gets married, goes to the other village. In that circumstances, if the Gaon Panchayat gives the certificate, but it needs to be proved again. The Honorable Apex Court also clearly laid down in that particular case.
My lord,
Right.
in this case also government secretary was issued. But I don't know where the petitioner also the trial both are silent in this matter, my lord.
That is the thing. Where is the authority of the Gambura to issue such a personal knowledge won't do.
Actually, the governor did not say that I know her. The known is whether personal knowledge from the records.
That's what we are saying. That whether he brought the record before the tribunal to show that the certificate that he had issued the record, that is enough.
That-
It's not the
Is not.
personal knowledge. You may know many.
That is fair, my lord. But I'm just a humble prayer, my lord, that while
Accepting this, any other ground you have.
my lord, the mother is still alive, my lord. That is another
That
thing.
doesn't matter whether the prosecutor has gave any producer, mother.
My lord, as your lordship knows, nowadays it is very simple because at the date of birth, mothers and fathers both namas there. But in earlier, mother's name and nama to be found. That is another thing. Nowadays, is birth certificate, even in my child minor, birth certificate of father, mother, both are there. So it is very simple for children to prove their who is father, mother. But earlier, it was not possible because the mother name was nowhere to be found. And nothing, no record, man.
True.
That is one problem, minor. That is the thing. Yes, deposed as DW2 minor, but that is
Deposed.
Ma-
What is her state?
she said that she is my daughter and sons and daughters are there. And she has produced an original voter ID card also, madam. So these are the things she has done. But as so far as any evidence is concerned, it is very hard to give any evidence because there are 6 or 7 children so there,
Is
madam.
there any voter list of Rositi's father and mother to get?
There is a voter list minor, but unfortunately they did not put it before at the time of trial and bundle. That is another thing.
The certificate copy.
This is not a certified copy. This is Xerox.
Whether it was exhibited 45.
No, that is not thing. That is the thing. The thing. They have
You could
given
have,
me a copy of the same, but I did not therefore I did not annex it with the petition.
you have obtained the certified copy in between.
I have
Could
to
have placed the 45.
I have to take instruction in this matter. Whether it is
Sharma.
আজিদা খাতুনের কথা বলছে আজিদা খাতুন হাজবেন্ডের লগত নাই তো তার মাকৰ কথা আজিদা খাতুনৰ মাকৰ
Earlier voter list. This is of 2014.
my lord.
Earlier voter list.
I don't know, my lord.
Mr. I am just pass on the. Take your seat, Mr. Todd. Have you read the evidence? You have read the evidence.
My lord. DW1 and DW2, my lord, I have.
You have read.
Yes, but DW3 I don't have.
Proceeding in her evidence before the tribunal say that there are six siblings.
Right.
right? Name them out of which to expel. The projected mother said 9 children. Proceedings said there are 6 siblings, along with the 2 expired. The mother, projected mother said she has 9 children, but named 10. While giving the names, she has named 10 per her own sons and daughters,
Okay.
right? And out of which 2 expired. Impossible. 18. Please come to Mr. Chaudhary, page number 22.
My lord.
Page number 22.
My lord,
You can read the vernacular.
my lord,
Now, one Fazar Ali's name figured in the voter list of 1965.
my lord,
He was 40 years old,
my lord.
from village Lailuri. Good. Then come to page number 24.
My lord.
One Khalik, right?
My lord,
Son of Fazar.
my lord.
His name figured in the voter list of voter list of 1971.
Okay.
Right?
My lord,
Is it acceptable? Is it acceptable? Is this voter list acceptable? If yes, kindly tell us yes, it is acceptable. And if no, tell us why it is not acceptable.
my lord. The full name is not there.
Only
Actually,
for
it
that
was,
reason?
my lord.
Only for that reason?
House number is different, my lord.
House number is reflected. And what else?
House number, he has changed the house, but I don't have to.
So the voter list of 1971 in the name of one Khalek is acceptable.
Abdul Khalek, my lord.
Abdul Khalek. Okay. Is it acceptable? Okay. What is the voting age? When did you vote? When you were 18 or something?
Hello.
Vote in at the age of 18.
My lord.
Earlier, when it was?
20,
Earlier to
21,
18, what was the voting
21,
age?
21. Earlier,
So,
20.
21.
My lord.
This person, age. Page number 24.
My lord.
What is his age?
20 years, my lord.
So-
That may be a typographical mistake because it's a voter list,
Everything,
my
it
lord.
is your document.
My lord. That is there. But if it is,
Okay. Now, coming back to the evidence of the proceedee said when she got married, she is not available.
my lord.
Mother did not state
My-
when she got married. Now, from the records, what we could trace is that the village headman who has given the certificate also stated that before I took charge,
She
she
got
was
married.
married.
But-
So he knew him,
Hmm.
knew her in fact,
Hmm.
from his early days or from his childhood or whatever. So it is his word, not from the record, from his personal knowledge. No value.
That is
Why there was no voter list, leaving aside this 1966 voter list of Fazar Ali, 65 voter list, and 70 a wrong voter list, 71 voter list of one Abdul Khalek, and it's showing 20 years. Why there are no other voter list of Abdul Khalek?
that I cannot say, my lord.
That's the reason the proceeding could have placed. They relied only in these two.
Two documents.
Just for your clarification. Okay, you have annexed certain documents, land documents, right?
My lord. I have not annexed the land documents, my lord. In the tribunal, my lord.
You have annexed.
My lord. But those documents were not proved, my lord, so I cannot rely on those documents. That is another thing.
First of all, the land document that was placed before the tribunal, it was a sale deed of 10th of June 1977, so post 1971
Fine.
document. Like no. Secondly, document was placed before the tribunal, which you get it from that app. Nowadays you can get it,
My lord.
the Jamabandis. There the Abdul Khalek was the owner of the land, son of Fazar. Now, India 2003, name of Abdul Khalek was incorporated in the Jamabandi by right of purchase pursuant to an order of the Circle Officer of 7/11/2003. Later, this order of the Circle Officer of 2013, November 2013, name of Muhammad Samsul Islam, father late Abdul Khalek. Muhammad Safiqul Islam, father late Abdul Khalek. Muhammad Mofizul Islam, father late Abdul Khalek. Muhammad Sirajuddin, father late Abdul Khalek. These are 4 sons. Muhammad Sajida Khatun, father late Abdul Khalek. Muhammad Azida Khatun, father late Abdul Khalek. Muhammad Mainara Khatun, father late Abdul Khalek. Muhammad Rasanara Khatun, father late Abdul Khalek. Muhammad Dasmina Khatun, father late Abdul Khalek. His names figured because substituted in the name of Abdul Khalek along with 2 wives of Abdul Khalek. So how many children?
4 sons.
6 daughters, 4 sons.
Okay.
10.
Two wives were there, my lord.
That's right.
Yeah.
10. Deposition of the proceeding. I was born and brought up at village Lailuri. I came to this tribunal to adduce evidence in the voter's case in my name. My father's name is late Abdul Khalek. My mother's name is Muhammad Rabida Begum Khatun. Father died. My grandfather's name is late Fazar Ali. My parents have 6 children. Keep this in mind. My parents have 6 children, namely Nur Jahan, Sajida Khatun, Safiqul, Azida Khatun, Samsul, Islam, and Minuara and Rosanara Khatun. My elder brother Sirajul and Apia, my elder sister, died. In the voter list, tell us that you have placed. Whose names are there? That photocopy, the voter list.
My lord. Well, Abdul Khalek is there, my lord.
Then Zubeda Khatun is there. Then
Safiqul Islam is there. Safiqul Islam.
Tafiqul Islam is there.
Samsul Islam is there, my lord.
Samsul Islam is there.
Tahira Khatun.
Tahira Khatun. Okay.
Asma Khatun.
They are son-in-law, daughter-in-law, not sons and daughters.
My
So
lord.
as per the proceeding, out of 6, 2 expired.
My lord.
Right?
My lord.
All were born at village Lailuri. I have not cast vote. I do not know when my marriage took place, but got married to Abdul Kalam of village Gereki. I have 2 sons and 2 daughters, namely such and such. They are studying in school at Rongzuli. My husband is some alive. He is a cultivator. My father cast vote. My father had 6 bighas of land property, but some of land sold. My sons by sold by his sons or something. I have got half bighas of land from my father, my husband, my mother cast vote. Now, mother, I came to adduce evidence on behalf of my daughter Azita Khatun in this tribunal. My husband's name is late Abdul Khalik. I have 3 sons. Now, listen carefully. I have 3 sons and 6 daughters, namely Nurjahan, Sajida Khatun, Minuara Khatun, Rosanara Khatun, Jasmina Khatun, Ajita Khatun, Sirajuddin, Safikul Islam, Samsul Islam, and Mahirul Islam. How many?
Total 9 combined.
Again, you count 6 daughters and 3 sons.
3 sons and 6 daughters. One is Safikul Islam.
Okay, just listen.
Mother.
3 sons and 6 daughters. Proceedings say 6, including those 2 have expired. Now here mother said 6 daughters, 3 sons. Now kindly count the names.
My lord,
Nurjahan, listen carefully. Nurjahan, Sajida Khatun, Minuara Khatun, Rosanara Khatun, Jasmina Khatun, Ajita Khatun, Sirajuddin, Safikul Islam, Samsul Islam, Mahijul Islam. How many?
9.
9 or 10?
9, my lord. 6
Two.
daughters and
3, 4, 5, 6, 7, 8, 9, 10.
10.
Count it. Count it, Mr. Chaudhary. We are
1.
giving you. Don't count that way. Count the names. Nurjahan,
Nurjahan,
Sajida Khatun,
Sajida Khatun 2,
Minuara Khatun,
3,
Rosanara Khatun,
3,
Jasmina Khatun,
5,
Ajida Khatun. How many daughters?
6.
6. Then you Sirajuddin, Safikul Islam, Samsul Islam, and Mohijul Islam. How many?
10 months.
Prosody is saying 6, mother is saying 9, and names are 10. Now listen. Sirajuddin Afia Khatun already died. Out of 10 minus 2, 8. And Prosody 6 minus 2, 4. My father's name is, you forget it. That's all. Now for an evidence before the tribunal, what is required? It should be reliable, trustworthy, and acceptable. Know the consequence. You don't need to hurt Mr. Paying any further. Hurt Mr. Restorative Counsel appearing for the petitioner. We'll come back at 2. Each police standing council election. Standing council home department for the election number 3, 6. Mr. P. Sharma. Regional General of the Transportation 5. Sir. Records of indicate number and in bracket number 3, bracket close in bracket capital D. 467 of 2015. That was called for by order dated 17 07/2015. Lecture is here. That will be the Mr. T. Sharma, training council bookkeeper.
Tribunal has taken a view. The landed tribunal has confirmedly and come to a specific conclusion that these two people may not be the same. So when these two people are there is a doubt that these two people are not the same. If the burden is on the proceeding to place on record that he or she is the same person, and the references are actually against the same person. That hasn't been done. And some other documents on the record will show that there has to be some serious doubt about the identity of these two people. And in case of res judicata, as your lordship is very much well aware, that the parties has to be same. Now that is the issue here. So whether the parties has to be same or not. But from the record, what I have consulted the record shows that there are differences, but then those differences have not been explained properly. So there is no explanation about certain differences. So that I'll point it out to your lordship. Now, lordship, first of all, lordship, the first reference was against first reference that it was 4593 of 2006, and special reference number IMDT 591 of 2000. The reference was made on 5/2/2001. It was against Muhammad Saleha Begum, wife of Muhammad Sanur Ali. So if we so lordship, I'll just refer to the records. So form 1, lordship, the record transpires that it has been written like this, lordship. Name of the person, Muhammad Saleha Begum, father late Qasim Ali, married. Particulars of the spouse, Muhammad Sanur Ali. So here the reference is against a person named Saleha Begum, whose husband's name is Sanur Ali. Now, if we come, if we go on, then we'll find that the address of the country, the village, the police station, then nothing has been disclosed here. Age has been shown as 22 years. And in page 2, it is found that she was having a son named Sanidul Ali, 1 year. And other relevant informations were not disclosed. Similarly, lordship, a form 2 also, the husband's name is specifically written as Sanur Ali. So we'll have to take that the reference was made against one Saleha Begum, whose husband's name is Sanur Ali. Now, if we go to the reference number 2 here, lordship, number 2 reference. Number 2 reference is, lordship, FT Nalbari case number 3/2009, and special reference number 128 of 2009, and reference was made on 11/12/2009. Now, if we go to that relevant part at page 9 of the record, so page 9, lordship, that is that interrogation report of the police. So here, lordship will find specifically in the columns, the reference was made against Muhammad Saleha Begum, aged 32 years. Then this Basai Kandi, that village name has been given. Then if lordship comes down, that column, that serial number 13, your lordship will find the husband's name. So husband's name is specifically written here very clearly, without any doubt, Muhammad Sanwar Hussain. Now, the first reference was against one Saleha Begum, whose husband's name was Sanur Ali. In the second reference which has come, the husband's name is Muhammad Sanwar Hussain. And there is no, I mean, Lord, so it's not that the names were similar, that some mistake has been cropped up. It's nothing like that. It's a very clearly it is written as Sanwar Hussain. So whether this proceeding has explained these differences, they haven't done. They haven't done so. They haven't stated this since this Sanwar Hussain may be the same person, and only saying will not do. They'll have to bring in certain evidence saying that this Sanwar Ali and the Sanur Ali and Sanwar Hussain is the same person. Otherwise, there is a difference of identification. Because the name may be similar. There are thousands of Saleha Begum. Maybe the village is also same. But what about the husband's name? Then Lordship, another document, very vital piece of document, that is Lordship, that cross-examination of the Gaubura. That is available in the record at page 15. So in the cross-examination of the Gaubura, Lordship, it has specifically come. I'll just read out that, I mean the statement, not in the cross-examination, in the statement, deposition. I am village headman of village Horiotali under police station and district Nalbari, Assam. Exhibit A is my certificate and Exhibit A1 is my signature with seal. By certificate A1, I certified that OP of this case, Muhammad Suleha Begum, wife of Muhammad Sanwar Hussain, daughter of Qasim Ali, village Horiotali under police station and district Nalbari. Lordship, in these circumstances, on this kind of, based on these materials, the Foreigners Tribunal has rightly opined that this principle of res judicata will not be applicable in this case.
So you want to say that the identity of this Saleha Begum
Yes,
and
yes,
the other Saleha Begum
yes,
is not same.
is not same. Because from the record, we cannot discern that these two persons are the same person from the record. So that is the reason why tribunal has rightly opined that these two cases are different. And that's why he hasn't taken into account the earlier opinion passed in the first reference of the FT. So question of res judicata will be applicable only when the parties are same. Now there is a serious doubt about the identity of these two persons. Now the proceeding has to prove before the tribunal that it is the same person, she is the same person. Once that is not done, the tribunal has to give an opinion saying that these two references are different. In the WS also, Lordship, that hasn't been stated. WS Lordship, would your Lordship like me to read out the whole WS? Nothing has been stated there. Also.
Okay.
So in WS also, Lordship, there is, it's a 2-page document, but nothing has been written in that paper. Another aspect of the matter in this, Lordship, if hypothetically, Lordship, if hypothetically we take it that is the same person, then also, Lordship, in our High Court has passed a judgment saying that to res judicata to be applicable, the orders have to be reasoned one, the judgments have to be reasoned one. Now we need to examine whether the order was that foreigners of FT1, the first reference, whether there was that order, that opinion was a reasoned one or not. I'll just take your Lordship to page.
No, because see that against the same particular decision, the state did not prefer any appeal. We have seen that. Now can we discuss that particular opinion?
No, in the context of res judicata, your Lordship. Only for the context of res judicata. State hasn't filed any appeal. That's sorry, they haven't filed any writ petition before this with this honorable. But as far as the context of res judicata, whether this, I mean, this first opinion could be taken as a reasoned opinion or not. If it is not a reasoned opinion, then res judicata will not be applicable.
That will amount to reviewing that. Because that matter is not before us.
Correct. The opinion is there, Lordship. Opinion is before your
Opinion
Lordship.
is that opinion is good or bad or they're not on that.
But only whether it was reasoned or not, Lordship. Because from the materials, whether it's
Whether it is not written. That case,
so in that case, res judicata will not be applicable.
there are two
Two references.
One reference was the second reference when it was made. The earlier reference was already pending. And then by the time the notice was issued in the second, the first proceeding was already over. Now it is the duty of the tribunal to find out whether the proceeding, first proceeding of the second came. Now here the proceeding with regard to the present problem, the tribunal from the verification of the record in earlier proceedings it did not point out from which particular village she came from,
Correct.
which part of the country or where she resided.
Those are not disclosed.
These were not here from the record during the inquiry because both are from the police. It was found that they disclosed that she is from Mymensingh.
Yes, yes.
She has something. So that's how the tribunal differentiated that the other proceeding and this proceeding not safe. The question of res judicata will be present. That's how it proceeds.
Correct.
Now, from the records you are submitting that since the father's name of the proceeding, the previous case is different,
Husband's name.
husband name is different, and in present case it is different. So they are two different persons, and they are not same. So the question of res judicata. So in that manner, should be proceeded further.
Yeah, correct, Lordship. Main issue is that only. Otherwise, Lordship, what actually Lordship is correct that Foreigners Tribunal hasn't discussed about whether the first reference was reasoned one or not. They have not discussed about this. So Lordship is saying that we will not touch into that matter because Foreigners Tribunal second one has not discussed about this. That is perfectly fine with me, Lordship. That is perfectly fine. Lordship is very correct. But as far as the identity is concerned, it is very apparent on the record.
Because we are in certiorari jurisdiction, we have to see that whether the finding of the tribe as the state procedure is the same. And now the second reference, the impugn opinion.
Not.
It could differentiate that it is not the same part.
Because there was no explanation coming that the same these two references are against the same person.
Okay.
So in that case, Lordship, in my humble submission, because there is a serious doubt about this, so the principle of res judicata will not be applicable in this case.
Yes, Mr. Das.
My lord, the first reference was made in 2000 and the second reference was made in 2009. So there was difference of age of 10 years, my lord. In the first reference, it was mentioned as her mention, age was mentioned as 22, and in 2009, it was mentioned as 32. So, my lord, there is no, the learned tribunal held that the age in the first reference was 22, but in the second reference 32. Therefore, this cannot be the same case, same person.
Hmm.
And also, the learned tribunal held that the petitioner had not disclosed her place of origin. My lord, her claim is that she is born in India. If she is born in India, she claims to be born in India. How can she disclose the name of her place in Bangladesh, my lord, if she was not born in Bangladesh? Now, regarding identity, my lord, in both the references, Saleh Begum, the petitioner, has been shown to be the daughter of Qasem Ali. And the village is the same, Shariat Ali, my lord. Only the name somewhere appears, the husband's name somewhere appears as Sanwar Ali and somewhere as Sanwar Hussain. Now, whether this discrepancy, Sanwar Hussain and Sanwar Ali, can lead us to the conclusion that Sadia Begum, son, daughter of Qasem Ali, is not the same as mentioned in the second reference, where the husband's name has been shown as Sanwar Hussain. Since the father's name is the same and the name of the village is the same, we cannot conclusively come to the opinion, my lord, that Saleh Begum of first reference is not the Saleh Begum of second reference. And regarding reasoning, my lord, that in the first reference, the learned tribunal has discussed the evidence and has specifically held that she is the daughter of Qasem Ali, of Shariat Ali. So he has given the reason, everything, my lord.
Mr. Khalil, just pass on the record for a while.
Lordship.
Hmm. Second, Yes, Mr. Das. Say basically, brother, as you know, he was in judicial side in his experience looking after the material, all the evidence. See, there has to be a link document between the proceedee and her father. Right? In 1965, there was a voter list at village Bhukwamari by the name of one Kashemal. Fine. After 1965, what happened? How the proceedee prove that she is the daughter of Qasim Ali? Only by mayor saying.
My lord, in both the references, the inquiry officer mentioned her father's name as Kasam Ali.
Is it enough? As because she is saying, the police officer is not aware. The proceedee said, my father's name is Qasim Ali. To prove one Qasim Ali, because in the inquiry report, there is nowhere that one accepting Qasim Ali.
Yes.
And she is a resident of Soriotoli. There was no mention that there is the Qasim Ali of Bhukwamari of district corporator.
Kasam Ali was of Bhukwamari village, my lord.
Is there anything in the police report?
Yes.
It was not there, neither in the first proceeding nor in the second proceeding, because it is the proceedee who submitted or he told before this, he told before police during investigation, my father's name is Qasim Ali. Qasim Ali of what? Qasim Ali of West Bengal, Qasim Ali of Assam, if it is Assam of which
It is
district?
government.
There is no mention.
Yes.
Now she has given a voter list of 1965 of one Qasim Ali.
Yes.
Now, who is this Qasim Ali? How the proceeding linked herself with Qasim Ali? As because he said Qasim Ali. Qasim Ali of which district? Qasim Ali of which village?
My lord, for this reason, I have got
Now,
one.
in the written statement, she said that my father's name figured in the voter list of 1965 from Bhukwamari, Qasim Ali. Now, the law is there has to be a continuity of Qasim Ali. Is there anywhere after 1965?
No, sir, not yet.
Then, and above there, how you have proved a link
My lord,
that you are the daughter of Qasim Ali?
my lord, I have back to draw Lok Sabha attention to annexure 1, my lord, 1.
Hmm.
Annexure 1.
Hmm.
Here, Gaonbura of village
Hmm.
He was not examined.
Bhukwamari, my lord.
Hmm.
Now here said, I'm reading in English, my lord.
Hmm.
For what purpose? This is link of marriage, link certificate of marriage. At page 6, my lord.
Page.
Page 6.
Hmm.
For what purpose? Link certificate of marriage.
Hmm.
Here it is mentioned, my lord.
Hmm.
The above mentioned lady was living in above village of Mailat. In 1998, she got married with Shanwar Ali, son of Sorhab Ali of village Soriatoli of Batahira, PS and district Nalbari.
Hmm. Hmm. That's right. Now, this was given by whom?
This was given by one Chandrakanta Odhikar, my lord. Gaonbura of village Bhukwamari, Koshuamari, Koshugaon.
Whether he was
Side
examined. No, no.
Next one, my lord.
That is what I said. Whether he was examined.
No.
Did he adduce any evidence before the tribunal? Whether this particular certificate.
No, I don't think, my lord.
So,
What
of all, the proceeding has to prove her link with her
And-
paternity. That where is there?
But Lordship, this this has been procured later on, after the pronouncement of the judgment. This was not on record
No,
before the
this is
acting.
not on record.
I don't know why this has been pointed out. The new document has been annexed in the writ petition, and like now he is pointing out this. This should not have been done by him. This was not on the record.
2nd of April 2017.
Yes, judgment or opinion was passed in Lordship in the month of March. 33, 2017, your Lordship. This should not have been done by my learned friend.
Anyway, village headman cannot issue the certificate.
Yes, yes. And this was not on record. How can we produce this? And this was procured after the pronouncement of the opinion.
Okay, we'll do one thing. Mr. Das,
Yes, ma'am.
we'll hear you on Tuesday. Right? We'll have make it hard in part. We'll make it on Tuesday.
My lord, subsequently, I have submitted some other documents as per order of this court, my lord.
No, records are here, so we don't have to, you have to go from the records only.
One linger certificate of SDU Zala Circle is there, my lord, in the record.
We'll go through that. Don't worry. Heard Mr. Bisidas, current counsel for the petition. Mr. A. Kolita. Attorney counsel from department. For the respondent number, right, assessed Roy. And this is for the respondent number 1. Mr. A. Kolita, attorney counsel from department for the respondent number 2, 3, and 5. H.K. Hazarika, government of production. Part in part, placed on hand. Record has been returned back. That may be not the Mr. G. Sir. Done it. Done it also. Okay. Well, on Tuesday we'll take it. Right.
Affidavit regarding dusty service on respondent number 428. Service is confirmed.
Who's the witness?
Worship
Who's the witness? The order
witness
says what?
in presence of witness. Yeah.
Where is the witness?
There is no witness.
How? You have also taken registered post.
Yes,
When? Can you will you able to take justice service afresh in presence of witnesses? Will you accept it? Will allow you one more time? Because you have not complied with that. You can, right? By our order, by order is it 4/1/2024. The applicant was allowed to take steps on the respondent number 545428 by registered post secretary on or before 09/01/2024. And in addition to the above, the applicants were also allowed to take steps on the respondent numbers 428 by the state of the personnel service to be routed through the registry of this court. Observing further that such trustee personnel service shall be made to those respondents by serving copy of this introductory applications, including the annexes appended thereto, by obtaining their signatures with date in presence of one or more witness, and thereafter the applicants are allowed to file an affidavit of completion such trustee personnel service. Pursuant to the state order dated 4/1/2024, the applicants on 09/01/2024 took steps the respondent number 428 by register 428 and services report. And service reports are evident on those. Further, the applicants also took steps the further, the applicants on (23/01/2024) filed an affidavit stating that they had already taken the step for service of notice on the respondent number 428 by personnel service. Public participation. In that regard, the said affidavit, the applicants have annexed the signatures of the respondent numbers 428 by the headmasters of the 5 INME school of the state herself. However, the state service of state personnel of the justice service on the respondent numbers 428 are not in conformity with the order dated 04/01/2024 as those were served, as the notices were served on the respondent number 428, in absence of any witness. View of table. The applicants are allowed to take each step the respondent numbers 4 to 8 by Dusty of the personnel serve to be rotated to the registry of this court. And such Dusty of the personnel service on the respondent numbers 4 to 8 shall be made by the applicant, obtaining their signatures with date and seal in presence of one or more witnesses, serving each of them a copy of this application determine this application. Such trustee of the personal service shall be made on the respondent number 4 to 8 by the applicant as directed on or before 28th of June. 28th of June. Thereafter, petitioner applicant shall file an additional affidavit in the matter regarding completion of such justifiable personal service number 4 to 8 as directed. List on 16th of July.
16 of last.
Yes, Mr. Devi.
Yes, Your Lordship. Lordship, I have received some instructions.
Do one thing, file a short affidavit. At least the applicant will come to know the reason. When
Lordship, 2 weeks.
RMSM does counsel a hearing for the review petition. Review of legal petition. Also heard Mr. P. Devi, Government Advocate Assam, for the respondent numbers before the due. Good name, ma'am.
Lordship, I am appearing for Education Department, lead account.
B Deca, full name,
Vibhashri Dekha.
MSP Deca,
For 4 and
Learned
5.
Standing Council, Education Department, Department of School Education. Then this is the Department of School Education. For the respondent numbers 1, 2, 3. Also heard Mr. B Deori, Government Advocate Assam, for the respondent numbers
4 and
4
5.
and 5. Mr. Deori and Government Advocate Assam have placed the relevant written instruction of the Deputy Commissioner, District Commissioner Lakhimpur, not Lakhimpur, pertaining to the decision of the district level committee for compassionate appointment of Lakhimpur district involved in the case of the review petition. The said written instruction dated 31/05/2024 for the two of the District Commissioner Lakhimpur be placed before the court by whoever affidavit to be filed by the respondent number 4 and 5.
4 and 5.
Such affidavit shall be filed by the respondent numbers 4 and 5 on or before 26/06/2024 by survey. Will that do?
Yes.
There is sufficient time you have to serving a copy of the state council for list of same date 16.
The blue light.
Yes, madam. What
May it please your lordship, my lord, notice was issued, I have taken steps.
you have taken steps?
I have served extra copies to
Oh.
Mr. T. Thakuria. And for respondent number 3, my lord, raised the post on 21 May.
Give it to us. You have served copy on whom?
Mr. T. Thakuria, my lord. First date he appeared on 30 May, he appeared, my lord.
Okay. Miss S. Bora, Learned Council appearing for the review of petition. Review of read petition. Submitted that steps have already been taken on the respondent numbers 1 and 2. By serving copies of this petition on Mr. T. Thakuria, London Standing Council, Department of School, Beckett Secondary Education. By filing the acceptance notice outside Mr. T. Thakuria. Right. Filing number, right, document number 2/204. By serving on 24/05/0. Right. document number 2 of the 2024 filed on 28/03/2020. So the data is certified. Ms. Bora also placed before the court that check on the response number 3 was taken by registered post lady on 28/03/2024. And to that extent, Ms. Bora submitted the document number 1 of the 2004 dated 02/05/2024. Issued by the registered. Also peruse the office note dated 03/06/2024 regarding the acceptance notice of the respondent on behalf of the respondent number 1 and 2 by Mr. T. Thakuria, right? Standing counsel.
Yes.
Department of School Urinwaka Secondary Education. Standing counsel department. As well as it is also seen that notice on the respondent number 3 had already been issued by registered post lady on 28/05/2024. Service report based on 16.
June. July.
Take back your acknowledgement.